Look at it as a bookie almost on betting. You should be, 59-41, or really you should be 50-50 on sales and buys, okay? That's not what's happening in these cases. What's happening in these spoofing cases is the sell side is so grossly disproportionate to the buy side, it's a joke.
In today's episode, we delve into the complex legal battle of Mullen Automotive against several market makers, including IMC Financial Markets, Clear Street Markets, and UBS Securities. Our guest, Wes Christian, represents Mullen Automotive, a California-based electric vehicle manufacturer that's facing a significant challenge in the stock market, allegedly due to an illegal trading practice known as spoofing. Spoofing is when market makers disseminate false information to manipulate stock prices. They do this by placing fake sale orders that are never meant to be executed, creating an illusion of a high supply and driving down the stock price. Now, proving spoofing is an incredibly high stakes and expensive process. I hope you find this interview as interesting as I did. The purpose of Lawsuit Review is to learn from the best lawyers in the country. This is a podcast made for plaintiff and referral lawyers and sponsored by my firm, Kirker Garcia. The only thing we ask is that if you're a lawyer who has a case similar to the one discussed in today's video, please consider joint venturing it with our guest. Their contact information is included in the research summary. But if you have another type of case that involves catastrophic injury or high-stakes litigation, please consider joint venturing your case with Kirker Garcia. We pride ourselves on maximizing case values by routinely taking cases to trial and winning. Our reputation at the courthouse has allowed our firm to routinely secure top dollar settlements. Additionally, we joint venture cases on a 50-50 basis with our referring counsel and front all case expenses. We have paid tens of millions of dollars in referral fees over just the past few years. But most importantly, we aren't afraid to recommend another law firm if we feel that somebody else is a better fit for your case. So if you have a case that you are considering joint venturing, click the link in the description to contact us, and we'll respond as soon as possible. Thank you. So the name of the case is Mullen Automotive versus IMC Financial Markets, Clear Street Markets, UBS Securities, and John Doe 1 through 10. So Wes, who do you represent?
I represent Mullen Automotive as a plaintiff in this case.
And who is Mullen Automotive?
Mullen Automotive is a company out of California. It's a Delaware company that essentially makes different kind of electrical vehicles. Just some of the recent ones is the Mullen 5RS, the Mullen Class 1 van, the Mullen Class 3 van, the Bollinger B1 and 2, the Bollinger B4. I could go down the list. Essentially, they are makers of electronic vehicles, and also have some other affiliated companies that are in the battery business, which is, of course, associated with the electric vehicles.
And this is a publicly traded company, correct?
It is. It's a company that presently is listed on the NASDAQ.
And so what is this case about?
What this case is about, which is just one example, Tom, of a systemic problem in our capital markets, okay? This case specifically, as it sits today, that will change over time, is a spoofing case. And spoofing is illegal. Just to put it in context, to give you some big optics, Morgan got fined $920 million, I think, for just spoofing the metal markets. That's just one group of spoofing events. And further, several of their people were prosecuted criminally and were convicted. And are going to get prison time unless they went on appeal.
And so for somebody like me who knows very little about securities, what is spoofing?
Spoofing is an illegal practice that typically is today used by market makers principally. A market maker, to put it in context, is someone who registers as a market maker and in essence creates activity in a particular stock or a group of particular stocks by in essence buying and selling shares all day themselves to create this activity. In this case, as we allege, spoofing means disseminating false information into the marketplace in order to manipulate the market. So the next question is, what is the nature of that false information? The answer is, it is posting sale orders that really have no economic purpose. They're fake. They're never intended to be consummated, but it's there to send a message to the market that says, wow, look at all these sell orders in this company. What the heck is going on? That then causes a pile-on effect. When supply exceeds demand, guess what's going to happen to the price, Tom? It's going to go down every time. And so, in essence, once it hits the bottom because of those illegal fake sale orders, then they go in and sell it up here, but buy it down here, okay, to cover. So it's a way to make a spread. And if you do that repeatedly, ultimately your stock is going to go to zero, okay? So
and who is they? Who are the ones placing these orders?
Okay, so in this case, we're alleging it's IMC Financial Markets, we're alleging it's Clear Street Markets, and we're alleging it's UBS Securities. So just to put this in perspective, on page 10 of our complaint, which, Tom, you can find on PACER, which is the federal court system, UBS posted 431 million shares orders that were baiting orders, okay? So we're not talking about something that happens every Tuesday. We're talking about something that typically is a logarithmically predestined and dialed into the software to make this happen, okay? We're alleging that Clear Street Markets did this on 39,642,000 shares, okay, and down the list. And of course, each time that happens, Mullen was selling shares into the marketplace because a public company's currency, Tom, is its cash, okay? It's its bank. So when you're selling shares into a manipulated market, then the law says those defendants that are manipulating the market owe you the difference between what your shares could have been sold for without their manipulation versus what they were sold for with the manipulation, times the number of shares sold. So for every share you sold, you're entitled to compensation, because under the federal statute, Tom, the 10b-5 statute, if you inject false information in the marketplace, which ultimately causes the market to be manipulated, okay, then you're liable. And then you have to prove who was damaged. Well, in this case, it's the corporation who has sold billions of shares into the marketplace at artificially depressed prices, causationally connected to these defendants' behavior. That's what we're alleging.
Sure. Yeah. And I'm looking at the chart here. I mean, with respect to UBS Securities, you claim it's a baiting order ratio of 625 to 1.
Yes.
So for every one actual transaction, there were 625 baiting orders.
Exactly. So look at it this way. If you're a real market maker, okay, look at it as a bookie almost on betting. You should be, 59-41, or really you should be 50-50 on sales and buys, okay? That's not what's happening in these cases. What's happening in these spoofing cases is the sell side is so grossly disproportionate to the buy side, it's a joke. So what the defendants have alleged, and you should look up some other cases that were before this case that are pending that are our cases in New York. The Harrington case, which is a spoofing case. We're already in discovery on that case. I can't discuss specifics, but let's just say I like very much what we're seeing. There is another case called Northwest Biotherapeutics, is also a spoofing case that I'm doing with a national firm called Cohen Milstein. And incidentally, I'm co-counsel on all these cases with a firm in New York. Alan Pollack is the partner in that firm. And so ultimately, he is equally responsible in some cases, if not more. He mainly drafted this complaint, frankly, his firm. So at the end of the day, this is a concerted effort by a bunch of committed plaintiff lawyers who, in my case, have been doing these cases for 22 years. And we've uncovered shares being sold that aren't delivered. That's a naked short selling case. We've covered stock that they loan that they don't have. That's a naked lending case. And we've discovered spoofing. All these events are attempting to rig the system by creating artificial supply that exceeds demand, causes the price to go down, and on the sidelines, the perpetrators make billions of dollars.
The named defendants are the market makers. Are there individuals logging on to their account on UBS Securities or IMC Financial or Clear Street Markets and physically placing an unordinary amount of these orders?
These defendants with their trading platform, algorithmically, we allege, predetermining how all this is to work, such that all these baiting orders really are preordained. They're preordained in the software itself. Okay.
Interesting.
Yeah. So you can program software to do a lot of things. Okay. But this is just a way that they've algorithmically figured this out. So this is all done at a very high speed. It's not something that, some human being sits down and does and says, okay, push the button. It doesn't happen that way. But that entire group of baiting orders is displayed such that public investors can see it, okay, and are concerned about it. It sends a message of this company's in trouble or something's going on that I don't know about as an investor, so I want to sell too, which of course then puts more sell side pressure on it.
And what would these market makers say in defense? I mean, I know you're at the very beginning of the case, but in your experience, what are they going to come out and tell you?
Well, what they've already come out and told us in the Harrington case and in the Northwest Bio case is, well, this is just bona fide market making. This is legitimate market making. We're supposed to be making markets, okay? Well, we say no, that isn't right, okay? You don't have, I'm making the number up, 75% of your daily transactions be sells and 25% be buys, okay? You don't have this kind of ratio that you just previously articulated. That's not bona fide market making. The key is bona fide market making, okay? The reason that term is also there, Tom, is in January 1 of 2005, Reg SHO was passed, Reg SHO, that's an acronym for short, that said, hey, you can no longer naked short sale, that is sell stock you don't deliver, which is mind-boggling that you can even do it, if you fit into this box. Well, one of the exceptions today, over the years, myself and a bunch of other people, the American Chamber of Commerce, attorney generals, other lawyers on my team, have eliminated a lot of the exceptions that Wall Street had. But the one we have not eliminated is that the market maker, the bona fide market makers, don't have to borrow stock before they short it, okay? Because in theory, they short it one day and then they cover it at the end of the day. Well, that's not what's happening, okay? So that exemption, if you will, for bona fide market making, which we say they are not doing clearly, they're taking the position that we're kind of exempt from borrowing shares because we're doing bona fide market making. And further, this activity you're complaining of is bona fide market making, so go away.
There's a layer of negligence here, correct? So even if you say, okay, you might not be doing this intentionally, the fact that you let your algorithms produce this obscure outcome is negligent, correct?
Well, except it should be, Tom, but the problem is, what duty do they owe us, okay? What duty do they owe us? In this case, Mullen. So negligence really doesn't work in these cases. Fraud does. We're also suing under 9A, 9 alpha. But ultimately, which is securities fraud, the
Sure.
negligence standard doesn't work because, as you know, as a plaintiff's lawyer, you know that the defendant has to owe the plaintiff a duty of some type. You know, the
Sure.
failure to keep a lookout if it's a car accident or whatever. So, but that doesn't exist here because of the nature of the relationship.
Yeah, that's so interesting. Because the fact that there's no duty didn't even cross my mind. I would think that if you're a publicly traded company, these market makers would have some sort of duty listing your stock. But I guess
it doesn't work, and there is no privity of contract. We don't have a contract with them either. So
this case is at its very early stages. What do you hope to get out of discovery? Because it sounds like all of this trading info is publicly available, so you probably already have a lot of the data that you need. Are you going to be looking for any specific type of like communications, or why was Mullen stock targeted in particular?
Well, it was, number one, I don't know why these individual defendants target him, but I will tell you, generically speaking, the type of companies that get targeted for manipulation are companies that are startup companies that have to raise a lot of capital, that are always needing cash, and therefore ultimately, if my game is to manipulate your stock or sell stock that I don't deliver or lend shares I don't have, my game ultimately is to put you out of business, okay? Because if I can put you out of business, I never have to cover anything. I never have to deliver any share I sold. I never have to deliver any share I lent. I never have to worry about spoofing because you're in bankruptcy court. And with the stroke of a pen, that bankruptcy judge is going to wash out the equity holders because, as you know, it's secured creditors, unsecured creditors, and equity holders. So the equity holders rarely get anything. So the end game is to kill the company. So simply stated, Tom, which is a disgusting concept in America, certain segments of Wall Street decided 20 years ago, I believe, this is my belief, to make more money off of killing companies than building them up. Because ultimately, they have figured out a way, again, some of the portions of Wall Street, not all of it, they figured out a way to rig the system by these various manipulative tools. The result of which is they make billions and billions of dollars off of these illegal practices.
How do we fix this?
It's a great question, one I've been asked many times. First, I want you to think about this concept, Tom. Is there any asset in the United States where you can sell it, give your cash to a buyer, and get nothing? Okay? The answer is no, there's not. If you sell somebody a car and you sell the same car to 99 other people and you take all the money, you'll be in jail by next Friday. Okay? But this is so large. It is so systemic. And incidentally, Tom, this isn't just limited to the United States. It is, I got data. We could talk all day, but in this segment, we don't have enough time to show you that this is an international problem because a lot of these firms have offices in Hong Kong, in London, in Ireland, in Scotland, in Iceland. I could go down the list. We're tracking all this because our team is growing and getting quite larger. So this is, I believe, and my former financial partner in this was John O'Quinn, who I represented personally for many years, because honestly, these cases cost a fortune, and back then I couldn't afford to do them. So this is the truth. So as he said, this is the largest commercial fraud in U.S. history. It dwarfs tobacco, it dwarfs opioids, it dwarfs all of it. But the problem is it is controlled by a cabal, a financial cabal that is so large, that is so bipartisan, that it takes a movement ultimately to bring this down. Well, your timing, Tom, is impeccable because we are at the top of the curve of that movement, in my belief. And this is going to start going downhill in our way. There are over 10 million people on Reddit, on Wall Street Bets, on Superstock, on MMTLP, and these various groups that have formed worldwide that are tired of this. There are tens of thousands of emails that the Congress has received. I'm already working with various committees in Congress to come up with rules. So what are those rules? You must deliver what you sell or go to jail, okay? If not, then unwind the transaction. You shouldn't be lending shares at all, but if you're going to lend it, you can only lend it one time before it's returned, because each time you give a proper locate on the same share to 10 different people, well, you just created 9 artificial shares because that person thinks they have a locate, which incidentally, the hedge fund paid the firm a lot of money for that locate, and that's a lie too. A lot of these firms are lending shares they don't have and taking the money. It's also about transparency. This all is done through dark pools. It's done through X-clearing, which is broker to broker, not through the DTC, which is how the audit trail works. It's done in nefarious ways through the dark of night, and it's done through computers that do it like this. And so, frankly, and incidentally, it's done paperless these days. In the old days, you had to deliver the stock for the money, the stock for the money. These days, it's paperless, so the auditors can't even keep up with it because it's banging around the globe, and it's almost like a cakewalk at church. There's 24 people walking, there's only 12 chairs. We figured out a way to stop the music, and 12 people are standing up. And guess what? It's you, buddy. You're the one that's doing it. So at the end of the day, this is how we've constructed this. Learning it the hard way. I didn't learn this at South Texas how to do it. I learned it in the School of Hard Knocks with a bunch of very smart people on a team that I'm proud to be the co-leader of, along with Alan Pollack. So
this is such an interesting area of the law. I would have never thought that it's such a systemic problem.
To give you a stat real quick before we get off, Rob Shapiro did a report, former Undersecretary of Commerce, 500 million to 1 billion shares per day. 500 million to 1 billion shares per day are sold but not timely delivered. Okay.
Wow.
Yeah.
Wow.
So,
Wes, if anybody watching this wants to contact your firm because they might be interested in hiring you or just having questions, where can we direct them?
Well, at this point, we represent mainly companies, but I'm happy. I have one person that fields the emails and the calls just on this litigation space. They could reach us at jchristian@christianatarlaw.com. Or you can call our office 713-659-7617. But I want to be clear that we just don't have the ability at this point to represent individual shareholders. Rather, we represent the companies that have much larger damage models. The theory being, once the company monetizes that claim, they will issue a dividend to the shareholders, because these cases are enormously expensive. And at this point, judges are not really in favor of class actions in this space with litigation funders. In many cases, we use litigation funders on this because it's $10 million to do a case. So
wow. Where do the case expenses go? Is it it's very time consuming to get all this data?
The experts are a fortune. The liability experts, the SEC experts, the damage experts, the spoofing experts, the naked short selling experts, the stock lending experts. I mean, experts is enormous expense in these cases. The number of depositions. Wow. I mean, in these cases, we looked at over 200 million pages of documents. So we have to do it through AI now, and with search terms, and it's very complex because the trading doesn't just go through one firm; it goes from here to here to here to here to here, and that's one trade. Okay, so and there's millions and millions of trades. So this is a very cumbersome, complex case. But at the end of the day, it's about lying, cheating, and stealing. It's about rigging the market, screwing the little guy while the financial cabal, makes their billions. And it's wrong, and it's going to stop. And it's either, you've learned this going to the great law school of South Texas College of Law, it's either the streets or the courts, okay? Well, the streets number is growing. So the courts now are finally paying attention. In fact, in the Harrington case, Tom, we just got a great landmark decision that says brokers now are not only responsible for the illegal activity they're doing, if they let their customers do illegal activity because they're failing to supervise it, they're liable for their customers' liability also. So that takes the damage model from X to 10X. That's going to change the playing field in this space. And you're going to see more firms get into this, and you're going to see the number of citizens. It's going to make the Boston Tea Party look like a cakewalk, okay? So that's where it's headed. So much like you do in your practice representing those that deserve justice, we're representing a different group in this litigation space that deserve justice. And so that's where we are.
Well, Wes, thank you so much for taking the time to talk to me today.
Tom, thank you for having me. Honored to do so, and keep representing the people that need it, buddy. You're in the right area of work. All right.